Welcome to the United States Patent and Trademark Office webinar series for experienced practitioners. We're off to a great start. My name is Marisa Terrell, and I'm an attorney in the Trademarks Customer Outreach Office. I am pleased to serve as your host today. Now, as an experienced practitioner, you undoubtedly have received a final refusal from a trademark examining attorney on the basis that your mark is merely descriptive, confusingly similar to existing marks, or otherwise ineligible for registration under the Trademark Act. Well, in today's presentation, we will discuss how to effectively respond to these refusals. We'll also provide some guidance on filing an appeal of a denied trademark application with the Trademark Trial and Appeal Board, the TTAB. Now, before I introduce our experts, Judge Lykos and Judge Cataldo, I'd like to share a few announcements with you. First, this session is being recorded for your convenience and captioning is available. Second, you will have access to the recording in about 3 weeks or so by visiting our website, uspto.gov. And today's presentation features a number of terrific slides. These slides will be emailed to you after the presentation. And finally, at the conclusion of the slide presentation, time permitting, we'll open up the discussion for questions. So please submit your question via the Q&A box. How? Simply type your question and hit enter. Now, we've got a record number of attendees today, so it's possible that we may not get to all the questions. That's okay, just bear with us. Finally, please be aware that the chat thread is for announcements only, and it's disabled for today's presentation. All right, let's get to the good part. At this point, I'd like to introduce our two expert presenters. First, we have Judge Peter Cataldo. Now, Peter Cataldo has been an administrative trademark judge with the Trademark Trial and Appeal Board since 2006. Judge Cataldo began his career with the USPTO in 1992 as a trademark examining attorney. In 1999, he joined the TTAB as an interlocutory staff attorney. He received his undergraduate degree in English from Canisius College and his Juris Doctorate from Albany Law School. Next, we have Judge Angela Lykos. Angela Lykos is also an administrative trademark judge with the TTAB. Judge Lykos began her career with the USPTO in 1994 as a trademark examining attorney. She subsequently served as a senior attorney before becoming an interlocutory attorney in 2000 at the TTAB. She's been in her current position as an administrative trademark judge since 2010. Judge Lykos received her undergraduate degree from Johns Hopkins University, her Master's of Arts in International Relations from the Johns Hopkins School of Advanced International Studies, SICE, and her Juris Doctorate from Duke University. And now I'd like to turn the program over to our judges. I think Judge Cataldo is going to start us off. Judge?
Thank you very much, Marisa, and thank you everyone for attending. We are delighted to be here today. We're going to take a dive into the deep end of ex parte appeals and hopefully emerge refreshed in the shallow end. I'm going to turn things over to Angela for our next slide.
Thank you, Peter. So we are going to start off with the foundation of the ex parte appeal process, which is building an effective record. It is critical that as a practitioner before the board representing clients, in order to overcome a refusal, argumentation will not suffice. It needs to be supported by relevant and probative evidence. Some of the overarching themes that Peter and I will be discussing on this topic pertain to timing. We will be emphasizing that it's better to build your factual record during prosecution early instead of waiting later. And also think about being purposeful in terms of building your record and devising your strategy early on during the prosecution phase instead of waiting until after a notice of appeal has been filed. So before we jump in, Peter, do you have any words to add about our general theme here about building a record?
No, I think you've about covered it.
Okay.
Now, when building a record, there are several common pitfalls. And as advanced practitioners, you may have noticed that examining attorneys will often backload the prosecution record. In other words, introduce a little bit of evidence in support of the initial office action and then wait until the final office action or even a denial of a request for reconsideration to introduce more of the record. There's no reason why you also need to do this, and there's many advantages to making your best evidentiary case early on in prosecution. If the examining attorney has issued a refusal of registration or a requirement, introduce your evidence. This may force the examining attorney's hand to either refine the arguments in favor of the refusal or the requirement, uh, possibly withdraw the requirement, or at the very least, realize that you have some strong evidence, and the examining attorney is going to also need to introduce probative evidence in order to maintain the refusal. Please do not wait until after a notice of appeal has been filed and the deadline for a request for reconsideration has lapsed to introduce critical evidence. Now, the board will entertain requests to remand for the introduction of new evidence. Emphasis on new evidence. If the evidence was previously available and you simply forgot or neglected to introduce it in a timely fashion during prosecution, remember that your request for remand has to be based on good cause, and the board may not find good cause under those circumstances. Angela?
Yes, Peter is raising a very important point here, which is that remand is not a matter of right, but is discretionary. And if good cause has not been shown, it will be denied. We also take into account the timing of the filing of the request for remand. So, as a general matter, um, requests for remand filed prior to the deadline for filing the applicant's appeal brief are going to be looked upon more favorably than a request for remand filed um, concurrent with a reply brief or even after the main appeal brief. So we want to reiterate that, again, timing here is crucial. And jumping over to our next slide, this is the point that we will be driving home multiple times throughout our discussion today, which is think about, as Peter mentioned earlier, a more effective tactic instead of after a first office action response, merely arguing against the refusal, whether that refusal is a Section 2D refusal, mere descriptiveness refusal. Instead of just merely arguing against the refusal and not submitting any evidence to support your arguments, you may want to consider uh, at this point introducing your strongest evidence, which may in turn prompt the examining attorney to withdraw the refusal. And of course, this would obviate the need for an appeal.
I would
Peter,
add two
do you have
points.
anything to add?
Yeah, I would add 2 points to this. First, the examination process is not necessarily adversarial, and this is also something that we're going to emphasize a few times today. Uh, there's really no strategic or tactical advantage to withholding your best evidence until the end of prosecution. Um, if you introduce probative evidence early on, you may force the examining attorney to refine the basis for the refusal of registration, and this will be useful for you later on in your briefing, and also may, as Angela noted, result in withdrawal of the refusal in the first place. Also, if you do request remand, please make sure you do not embed this in your trial brief. Make sure that it's separately noted and separately under a separate heading so that we can clearly see it. The last thing you want is for us to sit down to write a final decision and discover there's also a request for remand in here that we simply didn't see because it was embedded somewhere in the appeal brief.
That's another excellent point that Peter has raised. The best practice in terms of a request for remand is to file a separately captioned request for remand in writing. And for example, proposed amendments to an identification, which are proposed in the hopes of overcoming a Section 2D refusal. We have all seen appeals where such amendments are embedded in the actual brief. They can get overlooked by the paralegal who reviews the briefs. So you definitely want to file those requests in a separately captioned remand. But as Peter and I were emphasizing earlier, it's best to make that evidence of record or propose an amendment to the ID during the prosecution phase instead of waiting for a notice of appeal to be filed and jurisdiction resting with the board at that point. So let's jump on to the next topic here.
Internet evidence. Internet evidence is widely accepted in ex parte appeals, also in inter partes proceedings for that matter. It's fairly well established that valuable probative evidence is available on the internet, and the board doesn't hesitate to accept it. A few things that are very important. If you are introducing screenshots from internet websites, please include the full URL address and the date upon which the pages were accessed. This is important for a couple of reasons. The full URL address makes it clear, first of all, that this is a valid internet address, that it's also accessible to consumers in the United States, and the access date similarly serves the function of letting us know that the the website was accessed reasonably contemporaneously with the issues under consideration, that the address is current, and that the material that's on there is likely to still be there. Avoid.
Yes, yeah,
Go ahead.
as Peter has mentioned, in our ex parte appeals, we have recently in the past few years adopted the approach taken under SAFER in our inter parties cases, where essentially if by including this information, the URL address and the access date, it's essentially authenticated. Failure to include this information may result in the board not considering the evidence.
We'd also say you really want to avoid truncated search results from search engines. We are not particularly impressed that your client's mark appears first when a Google search is done of a particular term, because the top spots frequently are paid for, and all it proves is that your client was willing to shell out whatever was necessary in order to get this position. You have to pay particular attention to what exactly the search results state. And sometimes it's difficult when you are propounding the this information as evidence because you know the point that you wanted to get across. However, unless it's clearly evident from the face of the search result, it's not going to be particularly probative. And the one thing the board is not going to do is infer other information that may or may not be there. We usually take these things at face value for what they say on their face. So make sure that you submit a sufficient snippet of information on this web page that we can actually see the context that it's in and see that it's probative. Avoid submitting foreign websites with no U.S. exposure. I mean, clearly, if customers in the U.S. are not accessing this website, you're not going to get the opinion of the typical U.S. consumer. Also, whether it's internet evidence or any other type of evidence, avoid submitting blurry or illegible printouts. Once you upload something to TSDR or to the board, double check it, make sure that it's legible. You are held responsible for submitting legible evidence, and it would be really a shame if you submitted probative evidence that we can't consider because we simply can't read it.
Right, and as Peter just mentioned with this last point, you would be surprised at how often the judges see this problem with illegible printouts. So we definitely recommend that you double check it prior to uploading to our internet site. So another topic within the category of internet evidence is social media evidence. And what we're finding is that this is a category of evidence that practitioners are sometimes overlooking to their detriment. This type of evidence can be particularly useful, for example, to overcome a mere descriptiveness refusal or surname refusal by amending to Section 2F, proposing an amendment to Section 2F that your proposed mark has acquired distinctiveness. And it can be, if used correctly, probative on consumer perception and relevant to showing that consumers perceive your mark, your client's mark, in connection with those identified goods as as a brand name, as a source indicator, as opposed to just a merely descriptive term. So we strongly suggest that you take a look at evidence on Facebook, Instagram postings, Twitter feeds, YouTube, and also take a look at the number of hits on your client's website and consider using this type of evidence to bolster a claim of acquired distinctiveness. Peter, what do you think of social media evidence?
Oh, I think there's potentially a wealth of information on social media. Um, know your client's demographic. Um, Facebook is generally where the parents and grandparents reside. I guess that's us. Ouch. Instagram is where you find the kids, and TikTok is where you find the grandchildren. So your products and services, where are they being marketed? That may dictate where on social media you're going to find these things. YouTube. Um, there's extensive commentary on a lot of YouTube material, and some of it is inappropriate. For instance, a number of years ago, I looked up a Katy Perry song that I was not familiar with, and I was stunned to see that there were over 2 billion views. Now, even considering repeat viewings and bots that are just playing the thing on a loop, it would suggest that a significant portion of the world's population has seen this video. And there were literally thousands of comments. Admittedly, some of them had nothing to do with anything other than what Katy Perry was wearing and what her hair looked like. But some of them may have actually been useful if you're trying to determine, for instance, whether something in the lyrics was being used as a mark, how it's being recognized, how it's perceived. And you can get consumer perception there. Admittedly, some of it is you have to comb through a lot of chaff to get to the wheat, but it's there.
Right, right. Peter is correct that this can potentially be a game changer in terms of demonstrating acquired distinctiveness.
Um, Again, with internet evidence, the probative value. Now, you have to consider the source of the evidence because it definitely affects its probative value. A perfect example, uh, the value of a blog post depends on US consumer exposure and the credentials of the blogger. Now, if what we're talking about are consumer goods, you want the broadest scope of exposure possible. So you want to look to blog postings that are very popular, that are going to be visited by a great number of users. If your client is trying to protect a mark for a niche product or a niche service, for instance, robotic software for remote surgical application. All right, you don't expect this to be under consumer goods, and there might be a niche blog that's very useful because this is where the technicians and physicians who use these goods or use these services might reside and actually discuss techniques. But if it's a niche blog, please explain to us why this is probative under these circumstances.
Right, and also make sure that again that you're looking at the source of the blog. An individual who has no credentials, who as a hobby is blogging on a particular product or industry, the judges are going to take a get a close look at that and not accord that type of evidence great probative weight. By contrast, most of the major media outlets have corresponding bloggers and blog sites such as, for example, the New York Times, NPR, etc. Um, those are going to have more exposure than the rogue individual trying to make it as a blogger. So be careful. Again, blog evidence can be extremely effective in terms of demonstrating consumer protection of a proposed mark as a source indicator, but make sure that you are carefully reviewing the source.
Yeah, I would add that if there's numerous gripe sites out there, and we're less concerned with what consumers think of the quality of the goods or services, but how do they perceive the mark for which registration is sought?
Right, that's a great point. The gripe sites do not carry a great deal of probative weight, so we suggest that you don't even bother submitting that type of evidence. Another area of internet evidence, another subcategory, are the open source websites such as Wikipedia or the Urban Dictionary. Now, as experienced practitioners, I'm sure everyone here has seen board opinions um, citing in part Wikipedia evidence or the Urban Dictionary to support a refusal. And certainly it certainly can be probative when it is relevant. But we would strongly suggest that you don't don't merely rest your entire case on these types of open source references. Instead, look for websites, articles, and publications that carry authority in that particular field with regard to the identified goods or services and are relevant. In other words, again, similar to the blog example that we just discussed, you're looking for a credentialed website. And that is going to carry a lot of weight. We're not saying don't submit the Wikipedia evidence, but you can certainly strengthen your position by looking for online reference materials that are more credentialized and tailored to fit the particular refusal at hand.
Yeah,
Uh,
I would add to that. Um, be very careful if you're discussing vernacular or slang terms because they tend to become stale. Make sure that the term still means what you claim that it means, and also whether it's Wikipedia or blog evidence, um, people tend to speak in shorthand, especially when they're typing or texting because it's quicker. If there's a particular shorthand term that keeps being used in a particular thread, um, and it's not entirely clear what it means, don't be afraid to include a translation. Uh, in other words, that the board understands exactly what's going on. Um, Video gamers use certain shorthand terms. Um, Sports enthusiasts, uh, racing car enthusiasts use certain shorthand. Make sure that we know what's actually being said in shorthand so that we can actually give the proper weight to your evidence.
right, that's a great point, Peter. That can certainly help your strengthen your case.
Uh, Third-party registrations. Third-party registrations may be relied upon by the examining attorney and by the applicant. And now is as good a time as any to say that yes, sometimes we have dueling third-party registrations, and it's really a question of to what weight are we going to give them for the respective purposes for which they're submitted. And bear in mind, you may submit evidence for one point of law, but the evidence is in the record, and we will consider it for whatever point of law we consider to be probative. And this may fall outside the ambit of what you'd originally submitted or the reason you'd submitted it. And bear this in mind. Make sure that you don't submit anything that may help you on one point but undercut you on another. With regard to third-party registrations, uh, please do not submit any expired registrations. Any presumptions that inured in their benefit evaporated the moment they expired. Registrations lacking a demonstration of use. If the mark is not in use, even though it's registered, there is some questions to what extent U.S. consumers have ever been exposed to it. Um, Applications, again, are proof only that they were filed, and they really have very limited, if any, probative value. Um, Listings of registrations are not probative, even if we consider them of record because of the action or inaction of an examining attorney. For instance, the examining attorney didn't object to them or relied upon them in making his or her arguments. All they show is what they show. And again, we're not going to infer anything that is not present on the listing. And the listings tend to be very sparse. And they really don't have as much information as they may appear at first glance. Your best bet always is a full print of the registration from USPTO electronic records from TSDR, TSDR as some people call it, showing current status and title. Um, you may have commissioned a search report from a private company. We've seen these submitted in the past. The problem with search reports from private companies are they're not always completely accurate and up to date. Uh, the USPTO official records are held to be accurate and up to date. Uh, if you submit that, they really are very difficult to impeach on that ground.
Right. I'd like to reiterate the point that Peter just made about search reports. A much more effective piece of evidence is the actual TSCR printout. And again, make sure that it is showing the current status, title, and that you the whoever it is who is uploading the information onto our docketing system, that they actually click on and print out the goods and services. You would be surprised. We've actually seen some mistakes, clerical errors, where we have not been able to consider such printouts because they while we can see the mark and the status and title, we can't see what the goods and services are. So double check yourself before uploading onto our docketing system. So related to this topic of registrations, third party, and in particular, third party registration evidence. We're going to highlight now as an example the Section 2D refusal, which is the most common refusal that is made by examining attorneys, and also that we have on our docket of ex parte appeals. So one common pitfall that the judges have noticed is that in our post juice generation Jack Wolfskin world, applicants are not making effective use on arguments pertaining to commercial or conceptual weakness of the cited registration, the cited mark. So tying this in with the discussion that we just had about how to properly make third-party registrations of evidence, one of the most effective ways of showing conceptual or inherent weakness is to submit third-party registrations showing that that portion of the mark has been perhaps disclaimed by other registrants, or that it is very commonly, it's a common term that is registered by other parties. And as per the seminal case Tektronix, we use third-party registration evidence similar to dictionary evidence. So that, of course, is one effective tool that you have at your disposal. Um, Another effective tool to show conceptual weakness, again, are the dictionary definitions of a particular of the cited mark or a component of the cited mark. Again, we most of we basically almost never now see paper dictionaries in paper form. They're online dictionaries. But again, circling back to what we recently discussed, make sure that you have the URL, the access date, and that you are not relying on the British version of that dictionary, that you're relying on the US American English version. That is a common mistake that we will see. Peter, do you have anything to add about conceptual weakness?
No, you've covered all the points, particularly, make sure that you use a dictionary that's recognized and explains the term as used in common parlance in the United States.
Right, right. Okay, so now we're moving on to some of our case law as a reminder.
Right. Uh, those of you who've been in practice for a while remember when this discussion used the term fame. And the Federal Circuit and the board have moved away from fame because the strength of a mark is not a binary factor. It's not that a mark is either famous or not. Fame is not a finish line. In other words, the strength of a mark can vary from a essentially a very highly descriptive term that's issued on the supplemental register to an arbitrary term in long use that's registered on the principal register. These marks have very, very different inherent levels of strength. And we have to determine whether the mark in a cited registration or a portion thereof is very strong, very weak, or somewhere in the middle. Not surprisingly, many of them tend to be entitled to the ordinary scope of protection that a mark would be entitled to. And bearing in mind that any mark issued on the principal register is entitled to presumptions under Section 7 that it's valid, it's in use, it's owned by the named owner, and there's a certain the mark is inherently distinctive, even if it's suggestive. A suggestive mark is still an inherently distinctive mark for purposes of this discussion.
Right, that's an important point to keep in mind when attacking the strength and scope of protection that the cited mark in a Section 2D refusal is entitled to. Um, so now we're turning within this topic of scope of protection of the cited registration. We're now going to focus on the commercial or marketplace weakness of the cited mark. Um, the, the most typical type of evidence that we see in this regard are third-party website, business to consumer, B2C, direct to consumer websites, also online retail websites, showing that a particular mark or component of the mark is used by third parties, but unrelated to either the registrant or the applicant, um, to and making the term conceptually, I'm sorry, commercially weak. We want to caution you to carefully review the website evidence to make sure that it actually pertains to the registrant's goods or services, or goods or services that are related to those particular items. In Omaha Steaks, um, that's a Federal Circuit case that stands for that proposition that only third-party uses that pertain to related or identical goods or services are relevant. Um, and we also want to emphasize that again, turning back to what we discussed earlier, in making of record the third-party evidence, this again dovetails with the points that we made earlier of making sure that the complete website information is submitted with the URL and the access date. Um, just by way of illustration, we've seen cases where we have website evidence, but it's from 2016. That is not going to be relevant as something that was accessed in 2023. And then the other item that you want to keep in mind is the quantity of evidence. And a good marker would be to take a close look at Jack Wolfskin, Juice Generation, those cases for the number of third party website evidence uses that were submitted to show that a particular mark or term is commercially weak. Peter, I'm sure you have some things to add on this topic.
Oh, well, this could be in a topic in entirely unto itself for a webinar. Uh, Fame is fleeting. Strength is fleeting. If you had a mark that was wildly popular during the 1980s, uh, evidence that it was wildly popular during the 1980s, and you're now expanding into a new set of products and services, this may not be particularly useful. Again, as Angela pointed out, how is the mark being used today in 2023? Um, Whenever we talk about a sufficient quantity, the question always comes up, well, what is a sufficient quantity? And the answer, of course, like all things in the law, it varies. If you look at cases like Jack Wolfskin, Juice Generation, or board decisions in which the quality and quantity was considered to be probative, that will give you an idea of how much evidence was necessary in that particular case. And again, on that particular record, bear in mind, none of this evidence exists in a vacuum. We take into account uh, relative commercial and inherent strength or weakness of the cited mark, relatedness of the goods or services. If the goods or services are identical, it's going to be a much closer case. What other evidences of record? Um, there is there is no magic formula, and there's no number of that we can simply say, this will be sufficient. Again, there is really no finish line to speak of. You simply introduce the best evidence you can and make sure that it's relevant evidence. We really aren't concerned if there are numerous registrations of a mark for unrelated goods and services. It's apropos of nothing.
Right, that's an excellent point to keep in mind that we are required to balance the DuPont factors and also take into account whether the marks are identical or whether the goods are identical. And that does have an impact on our final determination. So keep that in mind when gauging how much evidence would suffice.
Evidence of conceptual weakness tends to consist of third-party registrations, also dictionary definitions. The Federal Circuit has indicated that third-party registrations can be used in a manner akin to a dictionary definition to show that a mark or a portion of a mark is commonly in use. It would be recognized by consumers, and then as a result, it's relatively weak. And again, I think we've covered a lot of this information in our previous discussion. Again, a sufficient number. How many? The answer is always, it depends. Uh, Dictionary definitions, again, we can't emphasize enough. There are numerous dictionaries that define terms. Having 10 definitions may not be more probative than having one or two. However, if you want to show that a term is widely recognized as having a particular meaning, introducing two or three definitions that tend to circle back to the same relevant meaning can be quite probative. And again, third-party registrations, make sure they're live, make sure they're use-based, and make sure that they identify the relevant goods and services. If you're relying on goods or services that are related to those at issue, explain why these ones are relevant. An interesting way to do that is to look at the examining attorney's own evidence. If the examining attorney is saying, well, these third-party uses or third-party registrations are relevant to show the relatedness of the goods or services. Well, if you submit that type of third-party registration, it's going to be very difficult for the examining attorney to argue that they're not probative. Another thing you can do, if the examining attorney introduces evidence of third-party use um, to show relatedness of goods or services, check and see if any of those entities also have trademark registrations. See what else they're registered for. This may put them into a larger context that you might find useful.
Right, and also to add about the dictionary definitions, where appropriate, if the goods or services are of a technical nature, just don't just simply rely on Merriam-Webster. Go to some uh, well-known, um, uh, reputable sources in the industry. Those will certainly carry more relevance and probative value. Right. So we wanted to just point out uh, to the audience some cases where the applicants were able to successfully overcome a Section 2D refusal. And the two cases are In Re FabFitFun, which dealt with a Section 2D refusal. The second case is In Re Lizzo. I'm sure some of you are familiar with her musical work. Um, which was a failure to function as a mark. And I'm going to turn over this part of the discussion to Peter because he was the decision writer in these cases.
All right. The examining attorney has the burden of proving that the refusal of registration or the requirement should be affirmed. So you really have three broad strategies to follow in trying to reverse a refusal or a requirement. First, simply point out the examining attorney has failed to meet the burden of submitting sufficient evidence to support the refusal or the requirement. Another way to do this is to submit evidence of your own to traverse some aspect of the refusal of registration. And that's what we saw in Re FabFitFun. The goods were identical, they were cosmetics of various types. The marks were I'm smoking hot. That was the applied for mark. The registered mark was smoking hot showtime. What applicants counsel did was submit third party use evidence to show that a sufficient number of third parties were using different permutations of smoking hot to identify their own cosmetics and hair care products related goods. This was sufficient to show the weakness of the common element in the cited registration. Now, bear in mind, applicants' counsel didn't show that the entire cited mark was weak, but only the term smoking hot that the two marks shared in common. That portion was weak. And that was sufficient to overcome a likelihood of confusion uh, refusal. In Ray Lizzo, failure to function. Failure to function is an interesting refusal of registration, and people will occasionally wonder, um, is it failure to function? Is it genericness? And we're going to discuss this later, but make absolutely certain you know what the examining attorney is refusing registration for, because there can be some conflation between the two. In this case, the examining attorney submitted fairly substantial amount of evidence that third parties were using the term at issue, which was 100% that bitch, which is a term it's actually a lyric from one of Lizzo's hit songs called Truth Hurts. And a very, very popular song. It was a Billboard top 10. In fact, I think it was number one at one point. And on articles of clothing, which is were the applied for goods, and an attempt to show that it was in such widespread use by third parties that it failed to function as a mark. What the applicant did was look very, very closely at the largely website evidence and discovered that much of it pointed to Lizzo. For instance, there'd be, you know, a tank top with the slogan on it. It's like, from the Lizzo song or Truth Hurts or something that would suggest an actual association with the applicant and managed to undercut a sufficient percentage of the examining attorney's evidence to result in a reversal of the refusal of registration, because there simply wasn't an indication that the mark was in such widespread use by third parties who were not aware of the original source of the goods as being the artist we call Lizzo. So, point out the weaknesses in the examining attorney's evidence, introduce countervailing evidence. There are many ways to overcome a refusal of registration. It never hurts to take a really close look at what has been presented. It may be a numerous amount of evidence, but if you can undercut its probative value, it's extremely effective.
Right. These are two excellent illustrations of effective marshaling of evidence that is relevant and probative to overcome refusals. So now we're going to move on to the topic of acquired distinctiveness, which of course is a common avenue that applicants and practitioners will pursue in order to overcome mere descriptiveness refusals, surnames, geographically descriptive refusals, etc. Uh, one common type of evidence that's used to show acquired distinctiveness are affidavits and declarations. And we just want to point out some pitfalls that the judges have noticed. One of the pitfalls is not choosing the appropriate witness who who can verify sales data, advertising data under the mark, and instead submitting a declaration but from the applicant's attorney of record in the appeal. Um, that is a mistake that we commonly see, and the attorney is not in the best position to have the necessary knowledge about an applicant's advertising or sales data, unless of course they're in-house corporate counsel. But we're discussing here the hypothetical of outside counsel representing an applicant. Another common pitfall that we see is making sure, failure to make sure that the statements that are made in the declaration or affidavit cover the relevant time period. So, for example, the declaration of the acquired distinctiveness statute, the declaration that tracks the statutory language, it states 5 years of substantially and of continuous substantially exclusive use, 5 years prior to the date of this statement. Make sure that your evidence covers that time period as of the date of that statement or prior thereto. It's best not to see gaps in terms of the timing. You want to make sure that you're not submitting evidence from 20 years ago, the sales data, advertising data under advertising expenditures, sales revenues under that mark from 20 years ago. And then there's a gap of 5 years, and then another few years, and then 1 or 2 years that are relevant. Make sure that you're looking at the relevant time period. And then the last point that we wanted to make on this particular slide is think about how you want to present the sales data or advertising expenditures. We do find that a chart format can be particularly effective and also just a very easy way for the judges to access that information. So that's something to consider in terms of the presentation of revenue and advertising data. Peter, do you have some words to add on this topic?
I would add to this that if the attorney is in the best position to verify the sales and advertising data, explain why. As Angela pointed out earlier, not only make sure the statements cover the relevant time period, make sure the declarant or the affiant was present during the relevant time period. Um, Sometimes you get young affiants talking about things that happened before they were born, and that's not terribly helpful. And this is not a directive to necessarily present your data in chart form. However, you can present it most easily and clearly is fine. Charts are sometimes very helpful for this sort of thing, particularly where you have lots of statistics and dates and numbers involved. And Angela, I think the next slide is yours.
Oh, form declarations. This is another way of showing acquired distinctiveness. And again, this frequently arises in the context of overcoming mere descriptiveness refusals. You need to keep in mind that form declarations from customers of the applicant are are scrutinized. They're very carefully scrutinized by the judges at the board. We take a look at how the particular items are, how these particular declarations are worded to make sure that they're not just mere forms. We also make sure that the the statements made in the declarations actually support a showing of acquired distinctiveness. So you want to make sure that you are not just using, if you are going to solicit declarations from a large number of customers of the applicant, try and include some individualized information.
No, I would simply add uh, a declaration is only as useful as the credentials of the declarant. And a form declaration can be useful as long as there's some information, as Angela stated. Who is the declarant? Why is this declarant in a position to speak to this particular topic? Large numbers of form declarations have repeatedly proven to be not really probative of much of anything in the past. Um, Continuing on this, choose your declarants wisely. Avoid declarants with an inherent bias. For instance, an employee of the applicant. Again, there may be a circumstance in which the employee may be in the best position to be your declarant. If that's the case, be prepared to explain why. Um, who's your customer base? Um, Make sure that your declarations speak to a sufficient base of your customers that we consider them to be probative. Um, Geographic and diversity and customer diversity also carries a great deal of probative weight. Now, if your client is operating in a region, make sure that's clear. Most of these declarants come from the greater Milwaukee and surrounding region because that's where applicant is located, looking to expand business into a wider area, but for the time being, we're operating regionally. All right, that explains why many of the declarants come from a particular area. But again, anything that's not clear on the face of the declaration or the application, be sure to explain to us. This way, we can put the declaration that you've given to us into a larger context.
Right. Those are all excellent points. And again, we want to reiterate that if there's some sort of self-serving or inherent bias, if all the quote unquote customer declarations are from employees of the applicant, um, they are not going to carry much probative value in improving acquired distinctiveness. So again, you want to avoid conclusory statements. For example, um, I attest that the mark XYZ has acquired distinctiveness. That is going to be um, pretty much disregarded by the ATJs, the judges, because it's a conclusion of law and not a fact. Um, Also, something that we have seen are declarations that use a true-false format, where the declarant just merely checks off a box. Again, that is not an effective uh, tool for showing acquired distinctiveness. You really want to include some individualized statements within that form declaration, and also have the declarant explain what their basis for knowledge is for understanding and perceiving the proposed mark as a source indicator for the identified goods or services. Peter, do you have some additional thoughts on form declarations?
No, I think we've pointed out their limitations sufficiently. Uh, Surveys. Uh, Contrary to what you might have heard, the board does not hate your surveys. However, very often we find surveys to be unpersuasive because they're flawed. Now, before you commission a survey, you have to consider, what is the purpose of a survey? It is to elicit customer perception of a term that's applied for as a mark. Can you find this from declarations of your clients? Can you find this on the internet, which provides, in many cases, direct consumer perception of a term? Is a survey necessary? Um, you have to scrutinize the methodology. What is the survey universe? Have you screened for qualified respondents? Is there any potential bias? Are the survey questions correctly framed? There's a great many things to get right here, which also means there's a great many things to get wrong.
Right, and you definitely want to make sure that you're getting a representative sampling, and that the again, with along with the form declarations, surveys are the type of evidence that the board will very carefully scrutinize. Expanding on this point, consider what the methodology is. So, for example, I'm sure many of you are familiar with the Teflon type methodology. And one illustration of a survey that formed part of the evidentiary record, and was carried a great deal of probative weight in terms of overcoming a genericness refusal is in the case in Ray Country Music Association. In that case, the applicant was able to successfully obviate a genericness refusal and obtain a registration pursuant to Section 2F. And the type of survey there, the Teflon type survey, that's a survey that in which the respondents are required, they're given a set of questions initially to screen out respondents who are unable to distinguish between trademarks or brand names of a product versus the generic term. So, for example, they'll be given a list of marks, well known trademarks, along with product names, like, for example, computer, refrigerator, or also the mark, for example, Coca-Cola. And then they have to indicate whether that's a trademark or brand name or a generic term. This way, the universe essentially screens out those respondents who don't understand the distinction between a trademark and a generic term. So this type of survey methodology, if done correctly, can be effective in overcoming genericness refusal.
And again, if you want to see a really good survey, in Ray Country Music Association, solid scientific methodology, a very effective survey. Um, In Ray Van Valkenburg, I'm quoting here, no basis on which to conclude that the survey is based on scientifically valid principles. If you're coming up with a novel method of conducting your survey, be prepared to explain why the results are probative. Very often they will not be. We see a great many surveys that simply fail because the methodology was considered so faulty. The results are not considered to be uh, accurate or reliable.
Right. And in that particular case, the applicant's counsel was mailed back the surveys, and they couldn't even determine the number of surveys that were mailed to an unknown universe of potential respondents. So definitely keep that in mind. So we're going to move on to another topic now. And now that you've successfully built your record, um, something else that we wanted to emphasize before we jump into the topic of briefing and brief writing and the art of brief writing is, and this is something that we think also gets overlooked by practitioners, is the importance of communicating with the examining attorney. Um, the examination process is not intended to be adversarial. You're not in federal court litigating a case. We strongly recommend that you pick up the telephone and communicate directly with the examining attorney as early as possible in the prosecution stage following issuance of a refusal or requirement, and and get solicit the thoughts of the examining attorney. um, you may be pleasantly surprised. You may be able to work out a resolution that could obviate an appeal. Um, Peter, do you have some words of wisdom to add in this regard?
I can only agree with you wholeheartedly and point out that we are, in fact, the U.S. Patent and Trademark Office, not the Internal Revenue Service. So, again, communicating with the examining attorney. Uh, Call the examining attorney and say, all right, what can I do to obviate the refusal of registration? There is no benefit to an examining attorney to maintaining a refusal of registration if a mark can be approved for publication. Will narrowing your ID um, obviate the refusal of registration? Bearing in mind, it needs to be narrowed. The original ID controls, and you can't expand it. Um, Other things, discuss with the examiner attorney what other options are available for different types of refusal of registration. If it's a 2E1 refusal, can the examining attorney recommend a 2F showing of acquired distinctiveness, an amendment to the supplemental register? Is your application and condition for such amendments? Um, there's really no harm in asking the examining attorney to discuss the actual nuts and bolts of what is this refusal about and how can I overcome it. Also, if there's any question as to exactly what issues are in play, make sure that you and the examining attorney agree of exactly what issues remain on appeal before the case gets to us, because occasionally we have cases where it appears that the applicant and the examining attorney are arguing slightly different facts, and that doesn't help anyone.
Right. And one of the areas where we see this disconnect is the question of whether a claim of Section 2F is made in the alternative or not. You want to make sure that that is very clear from the prosecution record, because then if the case does go on to an appeal, the issues are properly lined up for the judges for consideration. Um, some other suggestions that involve potentially communicating with the examining attorney, and also a couple other strategies to overcome Section 2D refusals are, you could move to suspend, check the status of the cited registration, um, see whether the grace period has lapsed for filing a Section 8 affidavit or Section 9 renewal. Sometimes there's a delay in canceling a registration by post-registration, so you want to double check that. Another tactic is to check the board docket at TTAB View to see if the cited registration is the subject of a petition to cancel brought by a third party. If so, that constitutes grounds for suspending prosecution. Another thought is you may want to advise your client to bring a petition to cancel themselves. And again, that would constitute grounds for moving to suspend.
I would say be very cognizant of the status of any cited registration, as Angela just pointed out. Investigate the owner of the cited registration. Ascertain whether the cited mark is still in use. Is the registration owner out of business? Is a petition to cancel available? Can you negotiate a consent agreement with the owner of a cited mark? Discuss with the examining attorney what elements would be required of a consent agreement. I would point out, and it's very important to remember, valid consent agreements are given great deference at the trademark examining operation, the Trademark Trial and Appeal Board, and the Federal Circuit. So they are a great way to obviate a likelihood of confusion refusal.
Right, and negotiating a consent agreement constitutes grounds for suspension of an appeal, so or suspension of prosecution. So keep that in mind. So now we're turning to our last topic, which is the art of brief writing and briefing. So we are, of course, working under the assumption that you have built an effective and relevant factual record, which is basically the foundation for your brief writing. And now we're getting into I'm taking a deep dive into writing the appeal brief. So one consideration that we advise practitioners to think about is keep in mind that the odds, the batting average, so to speak, is weighed against you, meaning that the majority of refusals are affirmed at the board. So keep that in mind when advising your client whether an appeal really is in their best interest or not. Um, if you have successfully built a record at this point, you may want to go for it and take a shot at the odds. But depending on what the nature of the mark is and the type of refusal, we are asking practitioners to be somewhat realistic about this process as well. Peter, what are your thoughts on the realities of appeals, ex parte appeals?
I would point out that the very high affirmance rate does not reflect any bias in favor of the trademark examining operation as a whole or trademark examining attorneys individually. It's a reflection of the reality that the trademark examining operation only maintains final refusals of registration in those relatively few cases in which it's felt that they have a very strong record and a good opportunity of affirmance. And this is borne out by the statistics. We understand that a lot of your decisions throughout prosecution and when it comes to the briefing stage and whether to file an appeal brief and go forward with an appeal are client driven. You're the experienced practitioner. You are in the best position to counsel your client on what is best uh, in their best interest. Practical considerations. Is this application simply a loser? Now, we also understand that the practitioner may not have been the person to originally file the application. The application may have been filed by applicant pro se or by someone who perhaps was not an experienced intellectual property practitioner and you are simply playing the hand that you've been dealt. And it could simply be that this hand is not a good one, and you might want to advise the client, look, this particular mark, unless you've got engaged in extensive marketing activities, is not going to be the best choice for you. Um, if the applicant really is set on registering this mark, you need to think, is the cited registration due to expire? Is it subject to third party cancellation? Are they amenable to a consent agreement, as we discussed earlier? Can you make a 2F claim to obviate a mere descriptiveness refusal? Or are you willing to appeal and risk an adverse TTAB decision that may have a preclusive effect?
Yeah, right. So now I'm turning now to the topic of the actual briefing. You've decided that you are moving ahead with the appeal. Again, reiterating the point that we've been turning to throughout our presentation. What does the record look like? Hopefully by now you have a sufficient record to support your arguments. Um, Taking a look at the examining attorney's evidence and critiquing it for its strengths and weaknesses. Again, for example, make sure if the examining attorney in a Section 2D refusal is supporting the second DuPont factor of relatedness using third party registrations, take the time to double check to ensure that all the registrations are use-based and that they are um, none of them are expired. That could be an effective tactic for attacking the examining attorney's case. And once again, as we mentioned earlier, make sure you double check the status of the cited registration to make sure that it hasn't been abandoned or um, it, in which case, if it has, you may advise your client to file a petition to cancel or whether a consent agreement is a realistic possibility.
Again, slide 30, this is your checklist. Are you ready to brief? You've already done these things. You're an experienced practitioner. Check them off. And we've really discussed all these matters earlier. It's worth mentioning them again, which is why we have at this point in the discussion because they do come up and they're easily overlooked. But you know, we've discussed really everything on this slide already. If you've taken these steps and you're ready to go forward, then you're ready to brief.
Right. And once again, a quick reminder, um, our practice, the ex parte appeals are not as the evidentiary rules are not as strict. They're more lax vis-a-vis the inter partes proceedings. The trademark rules of practice govern ex parte appeals. If you have any questions, take a look at Chapter 1200 of the Trademark Trial and Appeal Board Manual of Procedure, otherwise known as the TBMP. And also take a look at the Trademark Manual of Procedure, TMEP. These are very useful resources that essentially summarize what our practice is. It's a quick way to look up the significance and interpretation of a trademark rule, as well as looking as a source of relevant cases. Um, Also keep in mind that we follow TTAB precedent and Federal Circuit precedent. Occasionally, we will follow precedent, and of course, the U.S. Supreme Court. Occasionally, we will follow precedent outside of the Federal Circuit, but that's the exception, not the rule. And we'd like to also emphasize that non-presidential board opinions are not binding. So think carefully before citing to these types of opinions in your appeal brief.
Briefing strategies. Um, Be sure to address all of the refusals and all of the requirements in a clear and concise manner. Um, Emphasis on concise. You have a page limit. We look with disfavor on motions to exceed the page limit. It usually isn't necessary. And we've received a couple of questions on this already, and I thank whoever asked them. How do you want us to cite to the evidentiary record? Very simple. Cite to the evidentiary record on prosecution by TSDR to say the date on which it was submitted with what office action or what response and where it is in the record. And to your briefs and to anything that you've submitted at the board, cite by TTAB view. That is the best way to cite your materials. Point us to your best evidence. Don't make us look for it. Um, don't say, well, it's in here somewhere. The more directly you can point to your best evidence, the better it's going to be. Um, Obviously, as Angela just said, cite to Federal Circuit and TTAB refusals as whenever possible. Um, Please be certain to address all the outstanding refusals and requirements. Don't overlook a minor requirement that could be affirmed as conceded, and the board may simply say that's a sufficient basis to refuse registration and moot everything else. That would be a terrible shame. Finally, please do not attach any part of the record to your brief. It's not a courtesy, it's not convenient, and please do not cite to anything that you've attached to your brief that's already part of the record. It's much better to cite to TSDR and TTAB view.
Right, right. We want to reiterate there is no need to submit evidence that is already in the record. And of course, do not attempt to make untimely evidence of record by attaching it to the appeal brief. So just a couple common briefing pitfalls that we will run through quickly so that we have some time to address the questions. Um, Please do not repeat verbatim your last office action response. Again, think about what is relevant and what will be convincing in terms of overcoming the refusal now that it's up on appeal. We don't need to see a lot of string cites. The board judges are pretty familiar with the black letter case law, so no reason to waste your page limitation on long string cites. And again, an extensive discussion of legal standards. No need for that. We suggest that you focus on the evidence of record and how that supports your opinion. Again, as I just mentioned, do not attach untimely evidence to the brief. You are able to request judicial notice at the briefing stage. And if you do that, you do need to attach we generally take judicial notice from dictionaries, online dictionaries. That's the most common source. However, as we discussed earlier today, one of the points Peter and I are trying to drive home is the critical nature of making that evidence of record during the prosecution stage. Being prepared, being purposeful about building your record, and not waiting until the appeal brief to attempt to get in that dictionary definition that you think will make your case. Um, Another pitfall that we see are making arguments that, quite frankly, are statutorily unavailable. So, for example, arguing that your client has prior use of the mark in an ex parte appeal, that is unavailing because we are just only look priority is not at issue as opposed to an inter parties case. We're just focusing on likelihood of confusion. So keep that in mind as well.
I would like to say a brief word about judicial notice because I see we've gotten a couple of questions about that. Judicial notice uh, is something that's very sparingly applied. Now, you may notice that the Federal Circuit will take judicial notice of a wider range of material than the board will. This isn't us being recalcitrant. The Federal Circuit has actually warned us not to make extensive use of judicial notice. Generally, if something is not subject to reasonable dispute, we can take judicial notice of it. For instance, Utah is one of the United States. According to the US Census, English is the most popular spoken language in the United States, followed by Spanish. Um, if something's going to start an argument at the Thanksgiving dinner table, we cannot take judicial notice of it. It may seem like a funny way to articulate the rule, but that essentially is a fairly accurate way to do it. Now, in briefing, again, how can you refine the arguments that you made earlier in response to the examining attorney's argument? If you keep repeating the same arguments that you did in response to the first office action, the final office action, your request for reconsideration, um, well, they didn't work the first three times. Why are they going to work now? Try to refine them in response to the examining attorney's evidence and arguments. Um, do you really need to argue every aspect of a refusal or requirement? Um, should you file a reply brief? Now, to be honest with you, I generally do not. I won't make a negative inference on your failure to file a reply brief. If you feel as though your main brief states your case and the examining attorney hasn't raised any points that require a reply brief. On the other hand, if the examining attorney made a really good argument and well supported by evidence of record and you haven't addressed it, I'm going to wonder, why didn't you? Not a negative inference necessarily, but you've left a few questions unanswered. And again, look to undercut the examining attorney's own evidence and point to your own best evidence.
Right. And keep in mind again that with reply briefs that that's not the time to make your case. You are limited to issues raised by the examining attorney in their appeal brief. Um, Jumping to this next slide, again, we're emphasizing do not rely on non-presidential opinions, which are not binding on the board. If you think that a particular case is relevant, you can point that out, but we will take into account that it is non-presidential.
Raising novel arguments. Novel arguments advance the law some of the time, and they fail much of the time. If you're raising a novel issue, point it out. Explain why the board should make an exception to its usual practice or its case law. If you consider this to be a case of first impression, point out why you think it's a case of first impression. Um, don't be afraid to push at the margins of the established case law because this is how we create new case law. Having said that, I'm going to rely on the most succinct uh, maxim I've heard in this regard. Please do not advance the theory of the case, which, if adopted by me, is certain to result in reversal. And I see we have a number of questions here. Um, let me take a look. Um, do appeals ever settle? If so, how does that work? Now, if the applicant and the owner of a cited registration come to an agreement, by all means tell us. There's nothing worse than us issuing a decision, perhaps that is not in conformance with the agreement between the applicant and the holder of a cited registration after you've issued a consent agreement. Um, you don't really negotiate with the examining attorney. What you would do is potentially negotiate with the holder of a trademark. The examining attorneys aren't really in a position to negotiate. They're simply there to enforce the Lanham Act, and they're not parties. They're not represented parties. So really, there's no negotiation with trademark examining attorneys. Um, and I'm just going to read this question, Angela, if you want to take this one. When an appeal is suspended pending another TTAB proceeding, such as a cancellation, um, how do you let the TTAB know that the cancellation is successfully concluded? A motion to dismiss is moot, a request for remand, both?
Right. So what you need to do is just file a written communication with the board, noting that the cancellation has been concluded and that the Section 2D uh, refusal has now been moot and request that the appeal be dismissed. And that is, there's no need to request remand. Remand is only for requesting that jurisdiction be sent back to the examining attorney. There's no need for that here. The board can take care of that, and usually what will happen is the board paralegal will issue an order noting that the cancellation has been concluded and that the Section 2D refusal is now moot, and then the application will move on for registration. I will read this next question. You said third-party registrations can be helpful, but applications are not. What about applications that have been approved for publication? The answer is no, they're not helpful. Peter, do you want to expand on that?
As long as they remain applications, they are consigned to the same relative ignominy as they were earlier. However, this does raise an interesting point. Don't be afraid to refresh your evidentiary record. Sometimes pendency drags on for a bit. The internet evidence that you submitted in response to a first office action, and perhaps the applications that you didn't submit because they weren't probative. Now, perhaps 6 months, a year, or longer has gone by, and now you discover that there's more website evidence. The evidence that you had of third-party use has been refined. Some of these applications are now registrations, and now they may actually be probative. Don't be afraid to resubmit these and explain, listen, we're simply updating some of our earlier showings. If you are at the stage where you're ready to brief and you realize that there is new evidence, this is where it's a really good time to request remand and say, look, some of these applications on our registrations, we'd like to bring this to the board's attention. This website evidence has been updated. There's now more of it, and it wasn't available during examination. That's the sort of thing that we are likely to find good cause for.
Right, right. Jumping to the next question, where can we find TTAB opinions and results? Can you provide a link? We have that information on the landing page, the TTAB landing page of the USPTO website. There is a link to what is called the TTAB library, and you can formulate a search for refusals on TTAB final decisions on refusals that you are interested in. It's a very useful tool. It's free, which is nice, as opposed to Lexis or Westlaw. And you can even narrow the search down by goods and services, by refusals. So we suggest that you check that out.
And our manuals are similarly available on our website as well. Turning to our next question, should evidence such as web pages and copies of books and documents be provided with a declaration stating that the evidence is a true and correct copy? I would point out that in ex parte proceedings, the rules of evidence are somewhat relaxed. This is largely to account for the fact that the trademark examining operation operates under certain constraints and limitations to its own ability to adduce evidence. It's not strictly speaking necessary. There's certainly nothing wrong with doing this, and it can certainly be quite useful. If there's any question as to the provenance of this of the information, a declaration certainly wouldn't hurt.
Right, right. It won't hurt. Keep in mind, this is not, there's no notice of reliance procedure or requirement as there is in an inter parties case. And also keep in mind that SAFER now controls an ex parte appeals. So long as you have the URL and the access date on your webpage, you are good to go. Taking the next question. Oh, go ahead, Peter.
So this is Jason. So judges, just want to jump in real quick. So unfortunately, Marisa is having some technical difficulties and has been unable to pop in and ask you the questions that have been coming in. So I'm kind of stepping in her stead. We are right now at the end of time officially, but if you two are open to it, maybe we could stick around for a couple more minutes. I know we've had a lot of questions come in. We clearly are not going to be able to get to all of them, but would you guys be willing to hang out for a couple more minutes? Maybe answer a couple more questions?
Certainly.
Yeah, of course.
Okay, cool. Great. All right. Well, let's go ahead. If you want to take the next one, I think Judge Cataldo, were you going to maybe take the next one that's
Yes,
we have there? Yeah.
I'll take the next one. If an applicant wants to rely on a video such as YouTube, does the applicant need to make the whole video of record, or is it sufficient to provide a screenshot, a URL, and an excerpt of why the video is being relied upon? If the whole video needs to be made of record, what's the best way to do that? If you look in the TBMP, we do have procedures for making electronic evidence of record, and if a screenshot will do, that's fine. But again, context. If we can tell what it is that you're trying to submit the evidence to support by the screenshot, then a screenshot is plenty. If we need to see the entire video, you're probably better off showing us the entire video.
Yeah, I would err on the side of including the entire video. And also what would be very helpful is in addition to the actual video, keep in mind hyperlinks are not an acceptable way of making this evidence of record. Also including a transcript would be helpful as well. So jumping to the next question. Do the judges read the
Office actions.
OA's office actions and attached evidence and the ROAs and I'm assuming that's a request for reconsideration and office action?
Sorry about that, Judge. That's my fault. That's
That's
office
okay.
actions and response to office actions.
Okay, thank you.
Yeah, yeah. Yes, the judge who is assigned as decision writer, since as you all are aware, there are 3 judges on the panel. One of the judges is assigned as the decision writer, and part of that responsibility is to review the entire prosecution record. We never make a determination without having reviewed the entire prosecution record. So the short answer there is yes.
Yeah, I would agree, absolutely. And then frequently, if there's any question as to what's being referred to, the other members of the panel can also very easily jump in and take a look at the record. Also bear in mind, and I think we touched on this earlier, you may have submitted the evidence for a particular point of law. It's in the record, and we will use this to the extent it's applicable to any point of law that's presently before us. You may have said, "Oh, I want to use this for the weakness of the mark." Well, we'll consider it in the context of the weakness of the mark. If it has any bearing on the relatedness of the goods or services, we'll consider in that regard too, or any other regard. The evidence is in the record for any purpose. Our next question, aside from strategy benefits of submitting all evidence early, are you permitted to submit new evidence as part of a request for reconsideration? Absolutely. There seems to be some question about this. A request for reconsideration is a perfectly valid vehicle for introducing new evidence. Having said that, the examining attorney's office action, if it's a denial of the request for reconsideration, equally is a vehicle for introducing new evidence. So yes, this is your last chance to get evidence in.
Right, and there may be some confusion also between the distinction of what is a request for reconsideration versus request for remand. The request for reconsideration is essentially a matter of right. It's usually filed concurrent with the notice of appeal, but of course, under our new deadline, it has to be filed within 3 months of issuance of the final office action, absent an extension of time in which you're given 6 months. However, remands occur after that time period. So even if it's captioned as a request for reconsideration, it won't be treated as such. And a remand is filed following that time period. And again, as Peter and I mentioned, there's no right to a remand. There has to be a showing of good cause.
So we have we're actually over, so we're going to have to get out of here. But I tell you what, we do have one more question if we can sneak it in.
Sure.
So how about that last one there? So some TTAB cases vary in what is considered a probative number of relevant third-party citations that have been submitted to show common use of or conceptual weakness of a mark or various word portions. Is there a ballpark number that folks can consider as sufficient quantity of third-party regs?
I would have to say no. I would recommend look at decisions in which that evidence has been considered probative. How weak the mark was found to be based on what sort of showing was submitted. Again, it's not a binary factor. You're looking at various, if you only have a dozen or even half a dozen, if they're relevant, put them in. Don't add 20 more that aren't relevant to pad it. That's not really going to help you. Um, and we can assign to a mark a relative strength or weakness depending on your evidentiary record. Um, as far as a ballpark is concerned, no, because you play basketball in one court and you play baseball in another and high lie in a third, and these are different. They're different animals, and different evidentiary showings will be needed. That was a bad analogy. That's all I could come up with on really
No,
short
it's a
notice.
great analogy. And again, take a look at, as I'm going to reiterate what Peter just said, take a look at our precedent, Jack Wolfskin, Juice Generation, our Federal Circuit precedent on this issue, as well as board precedent. And that will give you an idea of what you should be aiming for.
And also, I would say look up the earlier precedent, AMF, which neither Jack Wolfskin nor Juice Generation overturned. It appears to have been qualified. Um, Again, there's a balancing act. One thing that's been, I think, clear from the Federal Circuit is hard numbers, finish lines, those sorts of things are being eschewed, and I think the Supreme Court would agree too. In inter partes and ex parte matters, um, we're looking for consumer perception and balancing tests as opposed to here's your finish line. If you cross it, you're in.
Excellent. I think that's a great way to end it. And also, I love the fact that's probably the first time highlight has ever been referenced in a USPTO webinar. So well done, Judge. Okay. All right, folks. So we do have to get out of here. We really appreciate your time joining us for more than an hour and a half. We do want to be respectful of your time, but we also want to give you as much information as we possibly can. So a big thank you to Judge Lykos and to Judge Cataldo for being with us today and for giving their expertise and the things that they have seen over the years. Also, unfortunately, Marisa couldn't come back and join us, but a big thanks to her for helping organize along with all the other folks at the Trademark Trial and Appeal Board and Ali, who is our tech for today. So thank you again for being here, folks. I know that some of you have been asking, hey, are there slides? Is there going to be a recording? The answer to both of those things is yes. The slides are available. Make sure to look in the chat. I'll try and throw it in there one more time. I'll give you the link to the slide deck so you can download it. But it has been in every email that you would have received about the login for this webinar through Eventbrite. You're going to probably get it in your email inbox real soon. Another email from Eventbrite, which has a link to the slides and also a link to a very quick survey we would love for you to fill out. And for those of you wanting a recording, we're hoping to have it loaded to our website and also on YouTube in about 3 weeks' time. Unfortunately, we can't give a precise number because we never know how long it's actually going to take to get it turned around. But be looking for that in about 3 weeks' time. And for those of you who want that CLE credit, we have applied for it in Virginia. Once we get the approval for that, we will be pushing out forms and information to all of those of you who attended today. So thank you so much for being with us and take care.